Well, welcome back. It's a great pleasure to be here today to continue these conversations about the other declarations of 1776. And we have the pleasure of hearing from a really wonderful panel with a couple of exciting papers that are going to kick this off by looking back from 1776, actually looking considerably back. The panelists we have today, so Charles Plambeck is Adjunct Professor of Law at the University of North Carolina School of Law, and his scholarship focuses on legal history and his teaching on international taxation, with or without representation, I guess. Prior to academia, he was a banker with Citigroup in London and New York, and an attorney in practice with a career that spanned Treasury Department and private law practice. And he will be speaking about the American Declarations of Rights and the ancient Constitution. And I'm going to introduce then Lorianne, who will follow up immediately, and then we'll introduce Laura Donohue, who will be providing commentary on that. So without further ado, we'll start with Professor Plambeck, and I will introduce Professors Schulzke and Donohue as we go.
Great, thank you very much. With apologies, if we can have the first slide. Yeah, and apologies with everybody, I've got to cover the English Civil Wars in 4 minutes, so that's not going to do it. Next slide, please. And also, no clickers, so we'll do this. So please go on. So the thesis of my paper is just to try to track the Declaration of Rights in 1776 back by grounding it in this notion of an ancient constitution, which was kind of in the vocabulary. The paper itself, please go on to the next. The paper itself really, of course, starts with Magna Carta and then the way the forms of government that we're familiar with really started to take shape under Edward I. It goes on to then really show how these concepts were worked out when the Stuart kings asserted absolute monarchy, and they were contested, first in the era with Lord Coke and the common law, next in the English Republic, and then after that, how they made their way into the British Atlantic Charters, and then finally how this it appeared in the Glorious Revolution. And then finally, how we got to the Declarations of 1776. It's a lot to cover, so I've decided just today to focus on the link between, next one please, just the link between the English Republic and the Declarations of 1776, because I think that's really very understudied. So if we can just kick that off, and this is just starting with the players because it's quite difficult. If we imagine that there was some unity on the British Isles before the Protestant Reformation, you might roughly say that there was a common form of government, a monarchy guarded by with an occasional parliament, and religion is the Catholic Church. And of course that starts coming apart and getting complicated with the Protestant Reformation. And so the first part of that, of course, is Henry VIII separating from the Catholic Church. But of course, the joke, I think the quip is that was Anglicanism was Catholicism without the Pope. The next most radical, more radical Reformation, I think, really is fair to say, took place in Scotland with the establishment of the Scottish Presbyterian Church. But then you still had I'm showing it particularly in the southeast England, you still had a lot of push for more reforms in the form of the dissenters, which would ultimately become Quakers, Baptists, Puritans, etc. So to set up the players, I'm then skipping the first half of the century, really, and just suggesting that there's really 3 players. This is all by way of introducing a key document that I'm going to talk about, by saying that a core group of them, of course, were the Royalists. And one thing I really want to emphasize in this very summary remark is how it's almost impossible to think about constitutional theory at the time separate from religion. And so you have the Royalist Party, which you could say is very interwoven between, of course, establishing absolute royal monarchical authority, but also very connected with an episcopal form of religion, the Church of England, and then you had Catholic support for that. The next party that was, of course, antagonistic to that was Parliament, but I think it's really then important to say that Parliament has really 2 factions. The one faction is the Presbyterians, who really represent probably the majority of Parliament, had more parliamentary control. And the Presbyterian goals, I think, were really to effectively replace Parliament's authority, replace the King's authority for Parliament's authority, both in matters of church and state. And the Independents, I contrast to them, are really essentially more tolerant of religion, not interested in establishing a state church, not per se objecting to Presbyterianism, but not wanting it to be dominant and therefore tolerant of people outside of the structured religion. Sorry, don't go quite yet. Stay there. Thank you. And so I think it's the independents that are important to focus on for this. The one thing I'll say is the independents also represent not just like strict, congregationalist, Puritans themselves. It's a pretty wide collective if you look at it of, lawyers, university-educated people, merchants, et cetera. So let's go on to the next. And so we start the Wars of the Three Kingdoms. I'm going to go through this kind of quickly. The point is that at the end of them, Parliament is supreme. Parliament has achieved military victory. And so what form of government gets implemented there? And so I think the key thing, let's go on to the next now. The key is really just the rise of then the pro-army faction of the independents. And I think it's important to understand that this splits. And what they're one thing to talk about the pro-army, and I think an important insight, is that in some sense, the soldiers themselves are very independent, very representative of the people, essentially. And for me, to think about it in modern terms, you almost think of it the way that a lot of African-American soldiers coming back from the world wars, having fought and put their lives for the country, wanted to assert rights. And I think that's an important part of understanding it. And let's go on. And it becomes clear in these now famous, I think they're famous, Putney debates, where they really start anticipating arguments for universal suffrage and just toleration for other people. So this effort sort of continues. Some of the more like radical leveler efforts are moved out, and we end up with the kind of quote unquote proto-constitution that I'll discuss, which is the agreement of the people. And this is put forward at a time when this pro-army faction is probably at their height of their power. They take control of the king and later execute him. So let's look at the details of that, because I think they'll become very familiar with you, to you. So the notable thing about, actually slow it down just a bit, sorry. The notable thing about the agreement of the people is, first of all, that it is actually very clearly a written constitution with a Republican form of government. And really, as you think about it, that's really no surprise, because the independents did not want to then have a parliament that ultimately could be despotic themselves, but they did want a parliament to be the Republican form of government. So how do you control that? You have to control that by restrictions on their charter, on their latitude of charter. So their idea was to have a House of Representatives, or representatives. They don't even call it in the document Parliament. They call it just the representatives. It's 400 people elected every 2 years. The election is much more equal and redistributed. It way anticipates the elimination of the rotten boroughs. And there's a voting franchise that in the earlier versions are linked to the amount of property and the amount of taxes one pays, and then it ultimately expands to just household suffrage. The executive side is all run by a council of state with representatives and chosen to manage public affairs, and it just eliminates the role of the king. And so the key thing also here that starts anticipating the American constitutions is a separation of powers to make sure that everybody's accountable and that there's no faction to corrupt that. So next slide. So as I mentioned, the real key thing is to how to give power to representatives but lessen their power so they don't become despotic in their own right. And there are really two strategies that these documents reflect. One is to make the parliament itself, or the representatives, more representative and accountable. And second, to restrict them by charter and disable them from affecting the liberty of individuals. So this is really, I think, to me, where we get a real clear origin of something that we can say is an ancestor to the Declaration of Rights, because they declare certain rights to be fundamental to our common right, liberty and safety. And these are reserved particulars. So it's out of the power of the representatives to modify or repeal. These are fixed. They're never delegated in the first place. And this also anticipates, I think, a judicial review of these things because it declares that any law made on these subjects, it has no binding force, anything that contradicts it. And it also distinguishes fundamental rights from just other rights that are good and useful. Other rights that are useful can be modified as society moves on, but the fundamental rights are impossible to change. So what are these enumerated rights they enumerate? Well, the first ones are actually reflect to representation. And as I mentioned, they actually give as a fundamental right the right to a proportionate representation, a share of the government. Free elections, which is a very ancient term that goes all the way back to 1275, the first statute of Westminster, is stated as a right. And these rights of biennial elections, which have a certain start and then a certain end for the parliament, is key. There's a statement that representatives cannot render up any of these rights, and let's go on to the next. And then really importantly, they also can't just level men's estates, destroy property, or make all things common. So it's a real reaction to the more radical elements which did want to have redistributed things. There's no redistribution in the final document. They provide as a fundamental right a republican form of government, and then you'll see some things that we see, we actually trace that back to Magna Carta, but we see in our current things, equal application of law, no special privileges, let's keep going. And then very key, freedom of religion. They really stand for the idea of a publicly supported Reformed Christian religion, but definitely not popery or prelacy. But the idea is no one's compelled to conform. Any religion which chooses so doesn't have to participate as long as they're not disturbing things. So no impressment is another big feature which was done. So we'll skip ahead to the end of the Republican limited monarchy, but the one thing I wanted to say that's like highlighted in orange is most of the American provinces, the chartered provinces, were actually born in the twilight of this revolution. You think about the charters that were granted to the Carolinas, for example, by the proprietors, and John Locke was the secretary to the proprietors. So a lot of these Republican ideas actually make their way into the expressions of the charters. Okay, let's keep going. And so the thread that goes on the English path goes on to parliamentary supremacy, and now we get to the Americans. So, yeah. So what I do at the end of my paper, let's please keep going, is to show that really, in summary, as the process of Constitution drafting begins, the idea originally is not really to reform the British Constitution, but to, it's to keep the British Constitution, but reform it. And with that, let's go on to just show this. They adopt, these declarations adopt very much the same framework that I talked about earlier. So next slide, please. So what I actually did, you can go ahead and click it again. I actually just mapped out the various declarations and identified maybe 35 different expressed enumerated rights. And it's interesting when you, go ahead. When you track that, about half the rights enumerated trace to the first half of the 17th century. And the other interesting thing to look at is which ones are original to the 17th century, which ones were American rights that hadn't been previously expressed. And one of them is the right to resist and replace an arbitrary government. That had not been, to my knowledge, been expressed as an individual right. The other is an evergreen idea of a recurrence to fundamental principles, and then the separation of powers. It's also interesting to think of rights not enumerated in there, which are the right to proportional representation, limitations on executive pardoning power, and protections against impressment. So I think I'll stop there just in the interest of time. I'll open it up to questions. There are a lot of questions about applying the blueprint in the present that we need to so let's just run through these, please. I think understanding our historical foundations is very key. I also think the function of these declarations as cohering society is very important. The representative government, the right to free election, this idea of equality of economic opportunity, and then also this idea of unenumerated rights. So that is an outline of my paper. Thank you.
Professor Plambeck. So next up, we have Professor Lorianne Updike Schulzke, who is Assistant Professor of Law at Northern Illinois University College of Law, and also a visiting Associate Professor of Law at the Yale Law School. Her teaching and scholarship focuses on constitutional law and history, And today she has a paper for us entitled Sufficient Bills of Rights. So, Professor Updike Schulzke.
Thank you, Professor Weinberger. And I think of all of the papers that you will hear today, Professor Plambeck's and mine actually fit together as best as you could hope for, actually, in a conference like this. So one of the takeaways of the paper that I'm presenting is that declarations, sorry to say, were not legally actionable. So for the people who are debating this afternoon, I'm sorry to say you have no cause of action, and I will show you the proof of that. This paper is more or less a part 2 of work that I've done. The part 1 is just out in the world, in the interweb, and some students here are actually studying it. Just accepted by the Pennsylvania Journal of their Constitutional Law Journal, and it's a corpus linguistic study of how Constitution was used between 1760 and 1799, drawn from the COFIA. I don't know what it stands for exactly. The Corpus of Founding American English or something like that, out of BYU. And what we found is really interesting, and that is that there are 2 definitions of a constitution. They still exist today. One is a description of institutions that evolve slowly and incrementally through the common law. And the other is contained in one written document that limits government and protects rights, what we're here to talk about today, and is fundamental, acts as fundamental law. So in that paper, I talk about not only the rise in the change that writing constitutions starting in 1776 had on the linguistic drift from one definition to the other, very sharp change. So now when we talk about a constitution generally in modern parlance, we mean the latter, which is the American definition, right? We're talking about a thing that you can hold up and point to and call a constitution. And that has implications and ramifications for textual meaning, because you're only choosing some concepts and not others. Others you're leaving below and you're elevating others. It has meaning for dualism, or this concept of having one law that governs another. So the paper that I'm presenting here is the final stage of this drift, because what we have is a constitution as it comes to mean, as the connotation shifts. By 1787, there is a growing, certainly not dominant, belief that constitutions not only refer to structures of government, but to rights. It includes both. This has not reached hegemony yet in the Constitutional Convention, as evidenced by the fact that those 3 who come, or it's really 2 who come forward, August 31st, September 12th, 15th, et cetera, at the end of the Constitutional Convention, to say, wait a minute, we don't have a constitution here. We can't have a constitution unless we have a Bill of Rights. They're poo-pooed. And they furiously, George Mason, foremost among these 2, writes his objections before he even leaves Philadelphia, and then circulates them, loses the friendship of Washington over this document. But this shift in meaning has implications. And I think that one of them is that simply the anti-federalists were not fighting against a constitution necessarily. They were fighting for a completed constitution. One that included not only structures, but a Bill of Rights. Now, of course, they had other griefs as well. And there's a lot of scholarship on this about the other things that the Anti-Federalists said, but the core, and in fact, of the Constitutional Convention, Elbridge Gerry from Massachusetts and George Mason say, look, we will sign on if you just give us this Bill of Rights thing. We can draft it up. You know, George Mason, of course, is the primary person who starts this thing called a Declaration of Rights. He's like, we can draft this up really quickly. And he's voted down 10-0. And it turns out that a Bill of Rights is what largely we'll talk about this a little bit, but the state conventions propose. And then once you get a Bill of Rights, when Madison finally changes his tune and Washington buys in, and then they get the federal Congress to buy in, anti-federalist movement disappears. And with that disappearance, we have a new meaning of a constitution, not one that's just a structure of government and the separation of powers and branches, but also rights. A constitution must include a bill, not a declaration, a bill of rights. Okay, so we've talked about now the people in the proto-anti-federalists, Mason, Albuquerque. Randolph is basically just a squish. He can't just make up his mind. He's for it before he's against it, and then he's for it. So we're going to just leave him to one side, even though his history hasn't treated him well. His papers are still not published, it turns out, and they're everywhere. But he's popular at the time in Virginia. And then later is made the Attorney General and the Secretary of State. So he's doing well, in part because he has a switch in time, and he then comes out in favor of the Constitution with amendments. Okay, so there's these three. They start the movement against the Constitution. They're Jerry and Mason both draft things that get them into a lot of trouble with all the Federalists. They're friends from the convention. And one of the press at this time is very pro-federalist. But there's a couple of things that escape their control, and one of them happens in Philadelphia. There's a great story behind the Pennsylvania minority, who are the Philadelphia radicals, and they have a story where the warden of the Pennsylvania State House for the Pennsylvania legislature goes and gets them out of their lodgings and physically, forcibly require them to be present to fulfill quorum requirements so that they can take the vote on calling a convention before Congress sends out their permission for states to do so. And so they bring their procedural concerns, of which they have many, and then present their substantive concerns. And they publish the Dissent of the Pennsylvania Minority that's republished everywhere. I think I'm positive, and Nicholas, maybe you can tell me whether or not I'm right, that the republication of the Pennsylvania Minority's Dissent is republished more than the Federalist Papers, certainly after the first 10. Okay, so that's correct. So it's published everywhere. Federalists are really upset by this, but it gives us a Bill of Rights. First and foremost, a Bill of Rights. And it looks very much like our Bill of Rights, except they identify a right to hunt. Our NRA lovers out there will be very happy about that. And you see this then, it's the minority there. It's also minority in Maryland, but in Massachusetts, the fifth state, so the Constitution, the Federalists know, if we push this really hard, really fast, we'll make more progress up front. And they do that in 4 states. And then they get to Massachusetts. And the farmers, now remember Shays' Rebellion? It also turns out that between 1776 and 1780, when we get the Massachusetts Constitution, there's another civil war in Massachusetts. Maybe war is a strong term, but the Western farmers in the Berkshires and in Hampshire, anybody been to the Berkshires? Lovely, right? Well, in 1776, they didn't behave themselves so well. And they prevented the judges from sitting until they got a constitution because they thought that the warmed over charter that the Continental Congress allowed them to have was insufficiently grounded in popular sovereignty as taught by Locke. And by golly, they had a right to resist. So they rejected a 1778 Constitution because, in part, for lack of a Bill of Rights. And here's the shift. Early on, they're called declarations. In Massachusetts, they start to call it a Bill of Rights. And that's one of the main objections that these Western farmers and others have to the draft. And by 1780, you finally have a Massachusetts Constitution that's replicated in New Hampshire, and also in Vermont. Northern New England, which I've lived in and loved, does a lot of great things and gets a lot of things right. Among them, abolishing slavery. But Vermont, actually, by the time you get to Vermont, in their constitution, which they copied from Pennsylvania, with the exception that theirs is called a constitution. They're finally calling it a constitution. Now, this is actually important. Let me back up a little bit. When the states start writing constitutions in 1776, they're not called constitutions. They don't know what to call these things because it's never been done before. A constitution comes from the British actually, there's in the work that my colleague and I have done, people are basically say, we don't know what a constitution is. Like, how do you define it? How do you define the British Constitution? But here they start calling them forms of government. Ooh, maybe that gives us some more content for a Republican form of government. They're talking about a constitution, not just a form of government, okay? Frames of government. But then George Mason introduces this concept of, we need a Declaration of Rights beforehand. And it's copied, but not everywhere. But by the time we get to Vermont in 1778 and 79, they write a constitution before they're a state. They're not made a state until 1791. It's called a constitution, and it has both a form and a Bill of Rights. Okay? They actually call it a declaration. But in Massachusetts, it's called a bill. And in New Hampshire in 1784, it's called a bill. So when we get to the US Constitution, this is now out there. And it takes Massachusetts and their convention and the majority, which to bring in the minority, they say, okay, we're going to make this thing called recommendatory amendments. And that then becomes a thing. And they start, it's then replicated many times over. We have 7 states, five majorities, 2 minorities. It happens in Virginia, it happens in New York. And this is the pressure that Madison begins to feel. I've only got 30 more seconds. I wanted to give you more time because I want more feedback. I might go just a little bit over because I have the extra 5 minutes, but I might just go a little bit over. Then we get to Madison in Virginia. Now, he actually is not very happy with the Constitution when it first passes. I think he goes through this melancholic period after his major proposals lose in the Constitutional Convention, and he writes to Jefferson and basically says, look, I lost on all these points. I'm not very happy with this. Jefferson writes back and says, yeah, but you need a Bill of Rights. You have to have a Bill of Rights. And that's the beginning of Madison changing his mind. He writes himself out of his funk by writing the Federalist Papers. And by the time he gets to Virginia and the convention, he basically says, we can do some. George Wythe proposes 3. But then he loses the Senate race because of Patrick Henry, his arch nemesis. And he basically then has to make a campaign promise. In his anti-federalist district, he's running against James Monroe, who's a lukewarm anti-federalist. And he says, look, we're going to do this thing called a Bill of Rights. And then he gets to Congress and he thinks it's going to be easy because it's called a tub to the whale. It's criticized as not going far enough. But he thinks nobody's going to disagree with this. It's largely cribbed from George Mason and all of these different recommendatory amendments. This will be fine. It'll get through fast. No. Congress is a federalist with the Constitution in sweeps a federalist Congress. And they're not buying it. Okay. Finally, he has to pull in Washington to get this Bill of Rights through. He does it, sends out 13, we get 10 back. Okay, so that by that point, we then have a definition of a constitution that means both a frame and a Bill of Rights. And forever after, in all human history since then, constitutions have meant, okay, Australians did their own thing. It's a penal colony. They do funny things there. I know I live there. But you have frames and bills of rights. Okay, what does this mean? Other than that we can rehabilitate the Anti-Federalists a little bit because they were actually for a constitution. I think it means that the Bill of Rights is legally actionable, whereas the declarations were not. Declarations were political instruments. This takes part of the British connotation of a constitution, where you don't have judicial review. No matter what Cook says, Most scholars think that particular case did not necessarily mean judicial review. And so here, but they become legally actionable at the time of the framing. And we see that. We don't see that until incorporation largely, but I believe at the time of the framing, the Bill of Rights is legally actionable and fundamental law that governs all others. Okay, I'm going to pause there. I don't think I went over my 5 minutes. Thank you very much.
Thank you to Professor Updike Schulzke. And now we get to hear some commentary on this from Professor Laura Donohue, who's the Scott Ginsburg Professor of Law and National Security at Georgetown. And she has written widely on, well, if I listed all of the subjects that she's written on, we'd be here for a while, ranging from constitutional law and theory, national security, and highly relevant today, legal history. So Professor Donohue.
Great, thank you very much. I would like to start just by thanking Anthony and Justice, as well as Lael and George Mason for the invitation to be here today. I was commenting to Anthony earlier, I love IJAG events because they're fun, they push the conversation forward, and I always come away from them with new insights. And today's panel proves no exception to this. Both Professor Plambeck and Professor Schulzke offer compelling, albeit differently focused, reassessments of American constitutional origins. While Professor Plambeck really focuses on the deep tissue continuity of English legal history, Professor Updike Schulzke focuses on the rapid linguistic and normative shift that occurred during the American founding. So in my remarks, I'm going to focus on 3 areas. First, highlighting the strengths and weaknesses of each of these papers. Second, comparing and contrasting them to bring them into dialogue. And third, looking at both professors' other corpus of work, 2 papers in particular, lend a lot of depth to the papers today and help to deepen new ideas that come out of actually blending these 2 papers together. So first, for today's paper, Professor Plambeck argues that the 1776 state declarations of rights were not sudden innovations, but really were continuations of a 750-year-old ancient constitution. So he traces this line of descent from, as we call it, MC, Magna Carta, and Edward I, through the English Republic, the interregnum period, to the American founding. So his central claim is that in the 1776 kind of formation of the United States, the founders used specific phrasing by reference to 2 millennia of legal wisdom. And I'm really sympathetic to this. I actually teach constitutional law. I begin with Magna Carta, 1215. We look at 1216, 17, and various statutory incorporation in 1297. We look at the English Bill of Rights, John Locke as an ex post facto justification. Then we're looking at the colonial experience, the framework of government in Pennsylvania, so on and so forth. Eventually we get to the Bill of Rights, the Declaration of Independence, So I'm quite sympathetic with this claim that when we look at, for instance, in the 1297 Magna Carta, clauses 39 and 40, right, where we get due process, we get concepts of proportionality from there. If you look at, clause 20 on fines, also in proportionality, like the 8th Amendment. Clause 21, you have a jury by one's peers, which incorporates then into the U.S. Constitution. There's a lot of persuasive power here in terms of his scholarship. Now, that is one of the strengths here, right? It is also one of the strengths that Professor Plambeck really focuses on this interregnum period, which a lot of scholars overlook. So the 1640 to 1660 period, he correctly notes here that this provides an early prototype for written constitutions that were incompetent, right, for a legislature to violate. He also, in terms of legal genealogy, he links the Statute of Westminster, which is the incorporation 1275, into the 1776 Declaration of Free Elections, providing kind of a concrete textual lineage for these concepts that are generally treated as Enlightenment era ideas. Now, where I might take issue, and I will say there are a whole number of issues that really fall on the shoals of word count. So unfortunately, JNSLP, I think you only have 10,000 words. So it is, I could kind of feel my colleagues at Cambridge like, at some of the broad sweeping generalizations that have to be made. and cover this much time. So leaving aside things like, the 1215 Magna Carta differed in important respects from 1297, and one could go through and cherry pick all this. That aside, where I might take you to task a little bit within the words that you have, is the problem of restoration versus innovation, right? So here you frame the 1776 fidelity to constitutional tradition. But then you also note that after 1688, the British Constitution settles into this parliamentary supremacy. So if that ancient Constitution is truly active, then the American break from this parliamentary supremacy would be a radical departure, not a continuation of that concept. Second is in the teleological risk. This essay risks a kind of Whig approach, right? Which views history as this inevitable march towards with these liberties. So while you argue that Edward I institutionalized is highly debatable when compared particularly to modern judicial review. Or another example is there are various points at which these ancient rights are crickets. They're throughout those hundreds of years that you're trying to kind of draw a swath over. And at least acknowledging that, I think, is going to be important to avoid this kind of anti-Whig attack, right, in how you lay that out. Okay, turning to Professor that the anti-federalists are not losers or detractors, but conformists who enforce this new norm, that a constitution is only complete if it contains both this and she frames this period between 1776 and 1791 as this period of linguistic drift, right, where the meaning of constitution shifts from this British evolutionary model into a unitary Britain model. This also has tremendous strengths here. I will comment because I think your other research really deepened the strengths of this. First of all, she's offering this more nuanced view of anti-federalism. So you successfully de-other, right, the anti-federalists by showing that their opposition was often a demand for a completed document as opposed to an attempt just to destroy the Union. And I think that's an important point in this research. Also, you offer this linguistic precision. So the distinction between aspirations and bills as legally actionable rights provides insight into how the founders viewed the enforceability of law itself. So there are two areas where I might take you to task. Even, again, this is all happened within a 10,000 word limit, which is like an intro or an is in terms of your oversimplification of the anti-federalists. So you claim that the movement out once the Bill of Rights was passed. I think this really overlooks some of the deeper anti-federalist structural grievances. For instance, the scale of the republic. Right, so the Montesquieuian kind of concern or question, which is whether a large, expansive republic could be successfully governed by a single governance mechanism. So Brutus, for instance, leveraged Montesquieu to argue that the government would inevitably become too detached from the people. Others raised concern about unchecked legislative power or unbounded power, where representatives become less and less accountable to their constituents, which paves the way for tyranny. The Roman republics, of course, provide this ready example, which is why we have these Roman names, with this idea that after a 500-year history, you have this loss of electoral integrity and the rise of despotic rule. So there are structural matters there that need to be addressed. Taxation powers would be another example of the federal government, which the Bill of Rights does not fully resolve, the taxation powers, right? See amendments, etc. The second weakness that I would highlight here is the Madison switch. So the Madison's pivot to supporting the Bill of Rights as the final stage of linguistic drift. But historical interpretations, and you today actually noted that Madison's switch might be purely pragmatic, right? Not actually some sort of principled philosophical convergence, but just a move to secure his election to Congress against James Monroe and prevent a second, more radical constitutional convention. So holding these two papers up against each other, in terms of the view of 1776, Professor Plambeck says, look, this was a restoration of 750-year-old principles, whereas Professor Updike Schulzke says, no, this was a redefinition of what a constitution is. In terms of the key precedent, they have different sources, right, as jumping off points. Professor Plambeck looks to the English Republic, 1647, whereas Professor Updike Schulzke looks at Massachusetts of 1780 and New Hampshire 1784. If you look at the role of the people, you know, for you, their role is they're the source of this ancient birthright, but for you, they're enforcers of a new norm. If you look at the legal status of the Constitution, right, for you, this is a reservation of power, but for you, this is fundamental law through dualism. So what spans or kind of connects these two is kind of the legislative tyranny bridge. So both authors seem to agree that action against unchecked legislative power. So for you, this is lessons learned from the Long Parliament, while for you, this is a reason why we see the shift from mere parchment barriers, right, as actionable bills. So using that, we can derive a new perspective on the American founding. First of all, that you have this hidden English Republican 47 Putney debates, combined with the 1778 Massachusetts rejection. That suggests that the American idea of popular sovereignty was actually transatlantic radicalism that had been simmering for 130 years. So the 1776 declarations weren't just English or American, they were the realization of this radical republicanism that the 1688 Glorious Revolution had actually suppressed in favor of parliamentary supremacy. Second is the sovereignty of the written. So Professor Updike Schulzke's linguistic drift suggests that the most radical act wasn't what the founders wrote, but that they wrote it, right? So by removing from the ancient Constitution, which is a Bill of Rights, which is a document, they shift that source of authority from ancestral custom to textual interpretation. So Marbury looks very different in this, like an inevitable outcome of this kind of shift that we see. And the third point I would raise here is just the suspicion. If you combine both views, then the Bill of Rights emerges as a legal bridge, essentially. But it places it in this unitary structure to satisfy modernists. So that explains why it's so successful in creating a coherent, diverse society, right? Looking backward while justifying moving forward. So we see the Constitution as really a Janus-faced document. It looks backward to the American Constitution, forward to written constitutionalism to exercise power, with the anti-federalists the one forcing this particular. No scholar writes in a vacuum. They have a corpus of work that really it's part of in our life trajectories, right? It's part of contributions to this. I found it incredibly helpful to deepen my own understanding of this work and broader scholarship. And there are two articles in particular that provide a granular deep dive into specific legal rights for Professor Plambeck, and for Professor Updike Schulzke, an empirical engine, corpus linguistics, basically, to support her linguistic drift thesis. So first on Professor Plambeck. He wrote a paper called this last year, it was published this last year, The Constitutional History of the North Carolina Free Elections Clause. It's in North Carolina Law Review in 2025. In this article, he really moves from a general constitutional theory to a specific legal battleground, specifically partisan gerrymandering. So in terms of the concrete lineage, he provides a rigorous path for the phrase, quote, elections ought to be free, basing it from the first statute of Westminster, again, Magna Carta 1275, through the English Declaration of Rights, 1688, and to the North Carolina Constitution of 1776. In terms of judicial mandate, he's arguing that the judiciary is not allowed to review election laws, but it's historically obliged to do so, to vindicate the rights of free election against legislative overreach. And then he uses this 750-year history to assault the 2023 court's decision in Harper 3, in which he claims that case subverted popular sovereignty in favor of legislative supremacy. About Harper and kind of what it contained. Now, the weakness here, just to throw that out and mention this, is that you insist as well in this paper on the meaning of these ancient words remained essentially unaltered. So you argue that because the 1776 founders used a 500-year-old phrase, they included, 2 millennia of wisdom by reference. But this overlooks Professor Updike Schulzke's argument from the paper she wrote for today, which is namely that by placing this ancient phrase into a unitary written constitution, it fundamentally changed the character. So reading phrases like partisan gerrymandering and proportional representation into 13th and 17th century texts is problematic here. So while you argue that these are the intended targets of the free elections phase, a traditional historian, which in some level I was raised as a traditional historian, might argue that that 1775 statute was much more concerned with physical force of arms and malice, right, at the polling site rather than abstract mathematical distribution of voters. The final point I'll raise is the paradox of regression. So you identify the ancient Constitution as this unbroken shield of liberty throughout your scholarship here. But you note that the 1835 North Carolina Constitution abolished the right of suffrage of free African American citizens. So if those rights are truly inviolable and retained powers of the people, then how does your framework actually explain how constitutional process could legally strip those rights away without the ancient Constitution itself being broken? So moving then to Professor Updike Schulzke's second paper, which is currently under journal review. Draws on AI to look at the kinds of claims that she's making. She studies 17,308 uses of the word constitution that the British definition, organic evolution, and the American definition, the fixed text, was not gradual. It was a sharp drift, highly correlated to the act of state constitution writing. Crucially, she finds that those two definitions were almost never used at the same time, 0.7% in her AI model. Now that is a heavy blow to historians like Jonathan
DNAP. I still don't know.
I know I don't say it right ever, but who argues that the founders blurred these two meanings, but it's a profound attack on how historians have understood this. And she clarifies that writing constitutions created this two-tiered system of law, this kind of constitutional dualism. Now, where I would take this on board, and then I'll finish with the final kind of bridge here, is formalism versus substantive continuity first. You focus on the writtenness, but you kind of overemphasize the container over the content, right, in this sense. So if you're right that the 1776 founders used the exact same ancient language, does the act of writing it down create a break or not with the past? It may under-account for the extent to which lawyers and judges continue to use common law reasoning, for instance, that transcend the text itself. Second is you have this reductive view of anti-federalists. You see them as forces of a new norm. I think you're sanitizing their radicalism and what they were actually doing at the time. They didn't just want a Bill of Rights. They had fundamental beefs with the structure of the federal government, including concerns about the scale, the broad powers of taxation, et cetera. And finally, there's the cutting room floor limitation. You suggest in both these papers that limiting interpretation to the text alone is kind of the effect of this, leaving the general law on the cutting room floor. But many historians actually argue to the contrary, that the terms of art used in the Constitution, like due process or trial by jury, are inherently open-ended and require that kind of general law in history that your claims are trying to dismiss, essentially.
So if we're going to get in a few questions, can we? But thank you for fantastic, incisive comments. So the only problem is that time is limited. If there are questions, as usual, microphones.
I think we were going to have time for back
side.
and forth. No.
So we can let's take some questions, and then if we have like a lightning round of reactions after that. But I think we've got, so we'll start here.
Hi, thank you. I'm Justin Pearson from the Institute for Justice. My question is for Professor Updike Schulzke. And I should preface
You
this
can
by
use
pointing-
Professor US if you want. That's what my
All right,
students
Professor
use.
US, I love it. I should preface this by pointing out I do a ton of state constitutional litigation. So I've noticed that throughout the country, many state constitutions have an Article 1 that's called Declaration of Rights, and often sue under provisions in those Article 1s. And so based on what you just said, Professor, I'm curious as to whether you think when those subsequent state constitutions were enacted, or even subsequent state constitutions in the original 13 states, why they chose the word Declaration of Rights instead of Bill of Rights. Like, was it that at that stage, those two terms had already become so commingled to the point where they just figured there was no distinction, so they would use the same phrase that they saw in the earlier state constitutions? Or were they actually doing that advisedly and trying to distinguish it from a Bill of Rights?
Should we do lightning round or should I respond?
So if you can respond quickly to the question, and let's try see if we can do the lightning round after we take a few questions.
Okay. Okay. So you bring up a really good point, and obviously my paper has a stopping point, and so your expertise goes beyond mine in this, and so because of this is outside of my purview, I'm gonna take a crack at it. So I think the distinguishing characteristic is like Vermont of whether or not they include in the naming of the document, do they include a declaration in the Constitution at this point? Because my instinct, I don't know, your knowledge is greater here. My instinct is that they're borrowing forward even though it has changed, but also now everybody realizes what's changed when it has, right? This linguistic drift happens, and we can show that quite clearly, but you still have people with their own opinions about what's happened, and it's not totally uniform. And at some point it settles and everybody realizes what's going on. But you might see that period. I don't know if later they call them bills versus declarations.
Most of them, most state constitutions still call them Declaration of Rights, and it's usually Article 1 of the state constitution.
Do you mind if I weigh in? So I think it's really clear the different meanings when you look at 1688, because 1688 originally had a Declaration of Rights, and then it was enacted as a Bill of Rights. I think the idea is that a declaration was maybe aspirational and a bill had statutory effect. But I don't think that's true with the state constitutions, because as a constitutional matter, you're declaring rights. You're not necessarily providing a bill. But I think they do have the effect of law, because most of the state constitutions will then, in the form of government, which is the second part, say that the bill is part of the Constitution. The declarations are part of the Constitution.
Not till Vermont.
Oh, no, that right away in North Carolina, for example. And Pennsylvania, yeah, I think a lot of places do it, yeah.
So in the naming conventions, I think it's really important of how they're called, because they don't use constitutions until the term constitution until later. Anyway, I think we're kind of done with it. Yeah.
Question here.
Great. I have a question for both of you, but mostly Professor Updike Schulzke. The other linguistic shift seems to be from the use of the word ought to shall. And I've read a lot of scholars who say the ought in the early declarations meant shall, and a lot who said, no, it means ought in the sense of hortatory. I'm wondering if your linguistic analysis sheds light on that, or if either of you have an opinion on that shift, which seems to parallel from declaration to bill.
So I think the answer to your question would actually require a ton of research, right? And this is why we're scholars. I think you would have to see how it was applied in court, right, to see if there is a shall there. And you'd also have to see, I haven't done the specific linguistic question between bills and forms, right? I have linguistic information about Constitution. So I could dig that out, figure out the ought from the shall here. But from what I can tell currently, initially it was ought.
Well,
I know it was ought. I'm just wondering what that meant.
I think the shift, so the ought is a very old English phrase, which actually, it's almost like a feudal obligation. It is basically shall, it's a command. You're obligated to do this, you ought to do this. So just as the meaning of ought has changed over time, modern constitutions switched to shall to still have the same compelling meaning, which ought started to be diluted over time. Yeah.
For Professor Plambeck, you gave a helpful sort of summary of the English Civil War, but in 1776, the Crown and its ministers referred to the American Revolution in part as the Presbyterian Rebellion. And I was wondering if that was purely limited to the concentration of the Presbyterians involved in the rebellion, or if you think it is sort of a recasting of the Presbyterian role in shaping the interregnum period.
That's interesting. I don't know, like the recasting by who, how it went. That's yeah. I don't know where that's, you know, the context of that statement and what they were trying to get by recasting that. I don't know if you can throw a little bit more. Maybe I can answer it. But why were they recasting it as a Presbyterian revolution only? I don't think it was. In fact, I think there was as much independence. There was much, you know, congregationalist participation as Presbyterian. But yeah.
I think statistically that's probably the case. It's just that the Crown identified the Presbyterians as the instigators of the American Revolution.
They were probably the best. They were probably the best organized and the best educated. Yeah.
Yeah. All right, we're down to our last minute and a half, and okay. All right. So we have Grace, executive, let's actually make the most of this. What if we get 2 questions on the floor that we'll go here, and then we'll kind of start answering them, and we'll still fit in lightning.
My question is not directed to anyone specific. Any observations on how religion influenced the constitutions or bills / declarations of rights?
Great, and we'll have pair of questions. And then
Actually, my question's for Professor Plambeck. How do you reconcile, I think similar to Professor Donohue's point, parliamentary supremacy in the UK with grounding it in ancient constitutional rights in the UK when it's when parliamentary supremacy is antithetical to the American judicial review system, and where Parliament technically could override those ancient constitutional rights?
Yeah.
How do you reconcile that with your
Yeah,
own?
well, this is what I think you have to kind of imagine it is like, this is a response to the continuity versus a break. It's a complete break if you think of the Glorious Revolution, as the parliamentary supremacy thing. It's a break from that. But if you like, your attachment point is a little bit higher and you start the concentration with the English Revolution, I think it's a continuation of those ideas. And so I think what was exactly happening in the American Revolution is really a rebellion against parliamentary supremacy. They may have had kind of a balanced government in theory with the king, meant to vindicate these old rights, which I'm arguing continue, but the king wasn't that actor. And I think that's an answer to your other things. Like, even though these are inviolable rights, doesn't mean they're not violated.
Professor U.S.
So I'm going to answer the religion question, then can I give 30 seconds of feedback as well? So it depended on the state. So you have a higher common denominator of religiosity at the time, but there was diversity across the states. And what's really fascinating is if you look at the Massachusetts and also New Hampshire constitutions, the towns identified that they had a right to an established religion. And I had a student at Yale that did a paper on this that he won't publish because it's so radical for anti-incorporation. But it did influence. Often it was in the background in the South, but in New England it was more in the forefront. Quick comment. I shared the Whiggish concern about the paper, but I think given the limits of the size, the English Republican stuff is so interesting. You should just focus on that.
That's a good idea. Yeah.
And what you presented here, there's far more depth than you have in the paper, and it was fascinating. But you also need to go through and show how it was influential, and who had access to it, and then not ignore the colonial context as well, where many colonies started long before.
Oh, absolutely. Yeah, and that to me is a thread. That's good advice. I'll just say on the religion question, just almost in order of enactment. I mean, Virginia, Pennsylvania, North Carolina, Delaware, Maryland all had religious liberty provisions in their Declaration of Rights, so it was very central to it.
If we can have a very quick last question, and I know Professor Donohue wants to have a final word as well.
Professor Updike, Schulzke, given your definition of the term form of government as meaning a piece of paper, what does that say about the guarantee clause? What does the guarantee clause guarantee?
Great question. I haven't written on this yet, but I want to, or have a student do it. Form of government meant not just a piece of, it was a constitution. So you were guaranteed a Republican constitution, not necessarily like, one person, one vote necessarily. And so it completely changes the meaning of the guarantee clause to it's constitutionalism, not necessarily one person, one vote.
Donohue?
Yeah, so since and I'm going to call this the myth of refinement. So both of you suggest that the founders improved or perfected the British model. So I think a more critical perspective might ask, if we move to a fixed written document, was that actually a way for elites just to contain popular sovereignty rather than to expand it? So by defining rights in this static text, they basically provide a floor for liberty, but also a ceiling that makes future organic evolution more difficult than under the British model. So this is not so much a refinement as a regression in the context of the British Constitution.
And with that,
I think just I think the fallacy is that so many constitutions also had this recurrence to fundamental liberties, or the idea that it was an ambulatory document, that's not the extent of your rights. That unenumerated right, it basically had an unenumerated rights provision in them. So.
and with that, this morning we have had the English professor apologize, and we have had an American university professor suggest that we have regressed with American constitutionalism. Thanks so much to this wonderful panel.